Most typical estate plans consider physical and tangible assets like land, buildings, personal belongings, or money. But what about assets that exist only online and in digital format? In one case involving Apple, an Ontario woman spent 4 years unsuccessfully trying to access an account that was jointly held with her deceased husband, despite the fact that she was also the executor appointed under his will. When the woman contacted Apple in 2017, she provided a copy of the death certificate and will designating her as the executor. However, Apple also required her to obtain a California court order before giving her access to her husband's account, a burden that could potentially cost thousands of dollars. Cases like these are becoming more common as more of people's lives are being managed online. More than 3 in 4 Canadians, or 78%, use the internet to conduct general online banking, and 1 in 6 use it to manage investments online, such as stocks, mutual funds, and cryptocurrencies. In Alberta, the percentage is even higher. In 2022, 84% of internet users in Alberta also bank online. But if something happens to the original account holder, like death or incapacity, it can be very difficult for their executors and other fiduciaries to gain access to their digital assets. This problem becomes even more challenging when dealing with international service providers who might not feel obligated to follow Canadian laws or court orders. So what is a digital asset? Digital assets are electronic records that may include everything from email and social media accounts, photos and videos stored online, loyalty reward programs, gaming profiles, and cryptocurrency. They include any information stored on a computer or digital device, content uploaded onto websites, and rights to digital properties such as domain names. Some digital assets have financial value. Others may have sentimental value, such as family photos posted on a social media account. So what's the problem? A person known as the account holder may have many digital assets. When an account holder creates a new digital asset, for example, opening a new email account, they enter into a service agreement with the custodian of the digital asset. Custodians can include online service providers such as Google, Apple, or Meta, or anyone else that holds, maintains, processes, receives, or stores electronic data of an account holder. These service agreements often have terms that limit or restrict an account holder's ability to share access information with a fiduciary, that is, a person with legal authority to deal with the account holder's digital assets. If that fiduciary tries to gain access to the digital asset when the account holder dies or becomes incapacitated, they may be prevented from doing so by the custodian according to the terms of the service agreement. While some online tools have been developed, such as password managers that could be used by fiduciaries to access a person's digital assets, these online tools are not a reliable way of transferring access information. Unless the law changes, many custodians, particularly those outside of Alberta, may refuse to provide access to the digital asset without a foreign court order. So how have other jurisdictions dealt with this problem? In the US, 48 states have passed laws to confirm fiduciary access to digital assets. Australia is also considering enacting legislation to close this gap in the law. In Canada, Saskatchewan, Prince Edward Island, New Brunswick, and the Yukon have all passed their own laws based off a model piece of legislation called the Uniform Access to Digital Assets by Fiduciaries Act. The Model Act was drafted by the Uniform Law Conference of Canada, Canada's oldest law reform organization that works to harmonize laws across Canada. The Uniform Access to Digital Assets by Fiduciaries Act was developed to affirm and codify a fiduciary's existing authority to deal with all of the assets of a deceased or incapacitated person without restriction on whether the asset is tangible or digital property. It does so by setting out default rules and access rights for fiduciaries, including a right to access the content of an electronic communication, a right to access a catalog of electronic communications sent or received by the account holder, a right to access any other digital asset in which the account holder has an interest, and a right to access, control, and copy digital assets to the extent permitted by Canadian copyright law. The Uniform Act also imposes obligations on custodians once proper documentation establishing a fiduciary's authority is received by the custodian. These include providing the fiduciary with access to the digital asset within 30 days and prohibiting custodians from using service agreements to opt out of Alberta law. This would void any provision in the service agreement that would limit a fiduciary's access to digital assets, unless the account holder expressly agreed to the provision after new legislation comes into force. So should Alberta enact the Uniform Act? Alri is recommending that yes, Alberta should enact a law specifically dealing with access to digital assets by fiduciaries. We consulted with a range of lawyers and estate professionals through in-person and virtual events, individual interviews, committee meetings, and written feedback. The majority of them expressed support for passing legislation in Alberta that would make it easier for fiduciaries to effectively and efficiently manage a person's estate, including their digital assets. An Alberta Act would also contribute to greater harmonization and uniformity with other Canadian provinces and US states that have passed similar laws. Greater harmonization can lead to more predictable results and better recognition of Canadian laws by custodians and online service providers in other jurisdictions. So where do we go from here? You can get our full report at www.alri.ualberta.ca, and you can like and share this video with your friends, family, and MLA. For more about this and other law reform projects, visit our website at www.alri.ualberta.ca.